You've probably seen a headline like this lately: born before 1975? The ATF's new July rules could make you a criminal without warning. Maybe it came up in your feed. Maybe someone in your gun club forwarded it to you. Either way, you're here because you want to know if any of it is true. So let me answer that directly, right now. The ATF did make real, significant changes in July 2026. But those changes don't target you. In fact, for most gun owners, especially collectors and retirees, they're the best news out of Washington in years. Here's the common belief you'll find online. People assume whenever the ATF announces new rules, it means more restrictions, more paperwork, more ways to accidentally end up on the wrong side of the law. That's been the pattern for a long time, so the fear makes sense. But here's what's actually happening, and this surprised even seasoned collectors when they dug into it. The July 2026 package isn't a crackdown, it's a rollback. 34 separate regulatory reforms, all moving in the same direction: less red tape, fewer restrictions, and a correction of some genuinely overreaching rules that federal courts had already started striking down anyway. Now, I've gone through the actual Federal Register filings, the Supreme Court decisions that triggered some of these changes, and the state-level laws that got tangled up in the public confusion. So what I'm sharing here is grounded in the primary documents, not commentary, not alarm. Here's how we're going to walk through this. First, I'll break down exactly what's in this rulemaking package, the real rules, not the headlines. Then I'll explain the 1975 confusion, where it actually comes from and why it has nothing to do with your birth year. After that, we'll cover what genuinely changed for three groups: NFA owners, pistol brace owners, and collectors. And finally, I'll tell you what you actually need to do, which, for most people watching this, is close to nothing. Let's get into it. Let's start with the rule that affected the most people and got the least clear coverage. Back in 2023, the ATF issued what's known as the stabilizing brace rule. The short version: if you owned a pistol with a brace attached, the kind of device originally designed to help veterans and people with disabilities stabilize a firearm with one hand, the federal government decided that some of those pistols now qualified as short-barreled rifles under the National Firearms Act. That meant registration. That meant a $200 tax stamp. And if you didn't comply, you were technically in possession of an unregistered NFA item, a federal felony. Estimates put the number of affected brace-equipped pistols somewhere in the tens of millions. Most owners had no idea they were potentially holding a regulated item. Many didn't register. Some ignored the rule on the advice of attorneys who said it was legally shaky. And those attorneys were right. Federal courts across multiple jurisdictions issued injunctions and stays, finding that the ATF had overstepped its statutory authority and violated the Administrative Procedure Act. The rule was a legal mess. The July 2026 package formally proposes to rescind those factoring criteria entirely. If this final rule goes through, and there's every indication it will, those tens of millions of brace owners are no longer living under the shadow of a potential federal charge for a firearm they bought legally at a gun store. For collectors and older owners especially, this matters. A lot of you purchased braced pistols years ago with zero intent to circumvent the NFA. You shouldn't have been in that position to begin with. This corrects it. That reversal was massive, but it's actually the second most misunderstood part of this whole story. The most misunderstood? The 1975 thing. Because once you understand where that number actually comes from, the whole panic narrative collapses. Here's the truth, and it's almost elegant in how it got scrambled. The year 1975 shows up in two completely separate legal contexts, and someone, somewhere, mixed them together into a headline designed to get clicks. In states like Kentucky and Idaho, hunters born before 1975 are exempt from mandatory hunter education certification. It's a grandfather clause. If you were hunting before formal safety programs existed, the state doesn't require you to go back and take the course. That's a state-level hunting regulation. It has nothing to do with federal gun ownership, criminal liability, or the ATF. Under federal firearms law, specifically 27 CFR Section 478.11, a firearm automatically qualifies as a curio or relic if it was manufactured at least 50 years ago. Not because of any legislative action, not because of any new rule. It's a rolling calendar threshold. In 2025, that 50-year line landed on 1975. Meaning firearms made in 1975, certain Colt pistols, Smith & Wesson revolvers, military surplus rifles, crossed into C and R status automatically. Now here's the irony, that transition is good news for collectors. C and R status means those firearms can be transferred directly to holders of a Type 03 collector FFL without going through a standard retail dealer. Less paperwork, lower cost. Easier acquisitions. Somewhere in the overlap of these two legal contexts, state hunting exemptions using 1975 as a birth year threshold, and 5 as a birth year threshold, and federal law using 1975 as a firearm age threshold, a headline was born that had no factual basis but enormous emotional impact. Born before 1975 is not in a single line of federal firearms law as a criminal standard. There is no regulation, no statute, no enforcement priority that targets gun owners based on their birth year. The people creating those headlines either didn't do the research, or they knew exactly what they were doing. If you own a suppressor, a short-barreled rifle, or another registered NFA item, you know about the travel paperwork. Under the previous rules, if you wanted to take that firearm across state lines, even temporarily, even for a hunting trip or a shooting competition, you were required to submit advance notice to the ATF before you left. The Form 5320.20, you'd fill it out, submit it, wait for approval, and carry the paperwork with you. Fail to do that, and you were technically transporting an NFA item without authorization. Another serious federal violation. The proposed rule change addresses this directly. For short-term travel, defined as 365 days or fewer, the advance notice requirement would be eliminated entirely. You'd be able to travel with your registered NFA items without pre-filing paperwork. The notification requirements would be reserved for permanent relocations only. Think about what this means practically. If you're a retiree who spends the winter in Arizona but lives in Montana, and you want to take your registered suppressed rifle with you, you used to have to file before every trip. Under the new proposal, that burden disappears for anything under a year. For people who own multiple NFA items, who travel frequently, or who simply forgot to file the form, this is a meaningful reduction in the risk of an accidental violation. This one is a bit more inside baseball, but it matters for a lot of you. Under previous regulatory expansions, the ATF had broadened its definition of who counts as being engaged in the business of dealing firearms. The concern was that some unlicensed sellers were operating essentially as commercial dealers without a federal firearms license, and the agency wanted to close that loophole. The problem is how broadly the rule was written. Under the expansive definition, a person selling off part of their collection, firearms they'd owned for years, not bought to resell, could theoretically be classified as a dealer operating without a license. Another federal violation. The 2026 proposal rolls that definition back to align strictly with the statutory text passed by Congress in the Bipartisan Safer Communities Act. The intent is to target genuine commercial operators who are channeling firearms to prohibited persons, not retirees liquidating firearms from a lifetime collection. This is a meaningful protection for the collector community. If you're selling off pieces from your collection, downsizing, or transferring family firearms as part of an estate, this rule ensures you're not inadvertently swept up in enforcement actions meant for black market arms dealers. Step back and look at the big picture. If you're an older gun owner, someone who's built a collection over decades, who owns some classic pieces from the 60s and 70s, who maybe has an NFA item or two registered long ago, the regulatory environment as of July 2026 is more favorable to you than it's been in years. The 1975 C&R milestone is real and it's beneficial. Firearms manufactured that year, and that's a significant category of American-made revolvers, pistols, and rifles, are now eligible for direct transfer to Type 03 collector FFL holders. If you have that license, your acquisition options just expanded. If you don't have one and you're a serious collector, it costs about $30 and gives you direct access to an enormous range of historically significant firearms. Federal inheritance rules also remain fully intact. Firearms passed to lawful heirs by bequest or intestate succession are explicitly protected, no out-of-state transfer penalties, no standard dealer requirement triggered. Family legacies are not in jeopardy. And critically, nothing in the July 2026 package creates new criminal exposure for ordinary gun owners. The rules don't add obligations. They remove them. Every final or proposed rule in this package moves in the direction of less paperwork, fewer fees, and fewer ways to accidentally run afoul of the law. The alarm you've heard online? It's backwards. The people most likely to benefit from these changes are exactly the older, longtime gun owners the headlines claimed were being targeted. Let's bring this together. We covered 5 things today. 1. The pistol brace rule, which put tens of millions of legal gun owners in regulatory limbo, is being formally rescinded. If you own a braced pistol, that threat is being withdrawn. 2. The born before 1975 framing has no basis in federal firearms law. It's a conflation of state hunting exemptions with a rolling firearm age classification. Your birth year is not in any federal compliance standard. 3. NFA owners will no longer need to file advance travel notices for trips under a year. Significant relief for anyone who travels with registered items. 4. The engaged in the business definition is being tightened back to statutory language, protecting casual sellers and collectors from being misclassified as unlicensed commercial dealers. 5. The 1975 C&R milestone is a real opportunity for collectors, not a threat. Firearms from that year now qualify for streamlined collector transfers. The pain point that brought you here was fear, the fear that new rules were coming for you specifically, that your collection, your habits, your history with firearms had suddenly become a liability. That fear was manufactured. The actual rules move in the opposite direction. You watched this video to get a straight answer. I hope that's what you got. If this helped you, share it with someone in your club or your circle who's been worried about the same thing. And if you want to go deeper on any of these specific rules, the C&R process, the NFA paperwork changes, or what the brace rescission means in practice, drop a comment below. I'll address the most common questions in a follow-up. Take care of yourselves out there.